case, you may be put in a situation where now, what happens when you go back to the court for the trial or whatever the next thing is? Your client's not there. You're there, and the judge is assuming that the facts are as presented in the documents that the client provided, and you know they're not. And you run the risk of if that comes to light, of the court saying you had a duty not to allow the court to continue to act on a false set of facts.
But removing false documents, just
okay, so
trying
just
to ethically represent someone you do not have contact with, where you're supposed to articulate their position on a number of issues, including whether their parental rights should be terminated. Should we stay on those cases? And if so, what do we say when we're in court?
So the issue is not whether there's any fraudulent documents, but just generally the client disappears, should you stay on the case? I think it's best to make a motion to the court to be relieved. If the court denies your motion, again, now you have justification. And what I worry about is, okay, the client's gone now, and you don't know where the client is now, but I'm sure some of these clients do come back eventually. And so now, maybe in the interim, you've taken action based on your good faith understanding of what they would have wanted you to do, but now they say, that's not at all what I wanted, and you should have known, I didn't want that, I wanted this. So at least if you bring the motion, and the court relieves you or doesn't, at least you performed your duty under the law, and if the court makes you stay on the case, you have no choice. You have to stay on the case, and then you do your best. Let me take 1, 2, 3.
Okay, more specific. You meet the client the first meeting, and he tells you, I want the children to be returned to the mother.
I don't want the
I
children.
do.
I do.
I want them to be returned to the mother. That's what I want. Never shows up again. Can you stay on, or should you stay on, and keep pushing that proposition to the court?
If the client gives you explicit instructions how they want you to pursue the case and then disappears, can you stay on the case?
Or should you, or,
I think if the client disappears, you're best off seeking to be relieved as counsel and explaining to the court in a like I said, in a motion submitted under seal, in an in-camera proceeding, and saying to the court, I don't want to do anything that's going to jeopardize the client's position, but my hands are tied. I cannot competently continue the representation because I have no ability to communicate with my client. But if, let's say, you've lost contact with the client, but you have reason to think that the client is still around. Maybe something opposing counsel has told you, or there's a relative who was helping you communicate with the client and they say, oh, the client's temporarily out of the country, whatever. I think you have some leeway there. But I do think if the client's giving you instructions and it's something like, I'm waiving my rights to parental custody, get that in writing and get it signed by the client so that, again, later, at least you have confirmation that this is what the client instructed you and that you're carrying out the client's wishes. And especially, I mean, you should always do it if you think that this is a client, you may be able to tell this is a client who seems to have a lot of issues and maybe this client is going to leave and I can sort of suspect that this is going to be somebody who I'm not going to be able to stay in contact with. The more you can document their instructions to you, the more leeway you have if a problem arises in the future.
My question is related, but what ethical issues are involved if you state on the record, which I hear many times, Your Honor, I've had no contact with my client, therefore I have no direction, and you take that position, what do you do then?
Well, again, I think that is a gray area, and there, for example, again, in the disqualification cases, there's a case called Manfredi where the lawyer filed a motion to be relieved as counsel on the basis that a conflict had arisen between the lawyer and the client. And the court said, you're not giving me any information as to what is the basis of the conflict. I can't rule on your motion unless you give me at least some idea, what is the basis? What's the factual predicate? And the court said, and the lawyer said, sorry, attorney-client privilege, I can't reveal anything. And the court said, well, then I'm sorry, but I'm not letting you out of the case. And they appealed it, and the appellate court upheld the court's ruling and said, you can't just make an unsupported assertion why you should be relieved. So, it puts the lawyer on a dilemma. You have to tell the court something. So stating I've lost contact with the client, I don't think is a revelation of any confidential communications. You're not saying, Your Honor, my client told me thus and such, and I think it's false, and that's why I need to get out. That's a lot different in character than simply saying, I cannot locate my client, I've done this, this, and this, I can't find an address, I don't know where they are. Your Honor, I cannot competently represent the client when I can't communicate with him or her. And I think that, you know, the court's going to require you to give them some basis for your motion, and that much, as long as you're not revealing the actual confidences, should not be considered to be any kind of ethical violation. Does someone have a thought? Yes?
Is there a reasonable amount of time where, like, can I wait, if it was just a month and I haven't had to come, is that too short of an amount of time? Should I wait 6 months?
I don't think that, that waiting a month is unreasonable. You know, and I do think it depends on the circumstances of the case. If you can show you had reason to believe that the client was temporarily unavailable, and, you know, maybe then 3 months is not unreasonable. But it's a question of totality of the circumstances. And I think if you're also during that period making an effort to try to locate the client, that also makes a longer period of time more reasonable. Yes?
The problem that we have as appointed counsel is that our cases are moving very, very fast, and our clients pop in and out. So they may come to a hearing, they may not come to the hearing, they may come back to the next hearing, and my concern is, where is it a motion to relieve, and where is it abandonment when that client pops back in at the next hearing and says, I told you this and this. In our courts, we stand for our clients, so we could argue without the client being there. And the client says, how could you have gotten relieved? And then the court goes forward without the person being represented.
Well, I think that because of the unique area in which you all practice, you do have more leeway. And so here's what I would say would be the factors that you should consider. If the court hearing at which you are appearing involves an issue where you have not gotten explicit directions from your client, and you're going to have to guess or speculate or presume what the client's going to want you to do, that's going to be a problem. If, on the other hand, it's more like a placekeeping appearance, it's a status conference, you're going to court, but really nothing substantive is going to happen that's going to affect the client's case, I don't have a problem with you continuing representation. I don't think anybody would criticize you for that. So I think you have to look at the case on a continuum and make a decision whether you're being called upon when you make that court appearance to take a position on behalf of the client when you don't know whether the client has authorized you to take that position. And if you're taking a position where the client has not authorized you, then I think you should consider asking for a continuance or seeking by stipulation if that hearing can be put over, or if you really feel that you're being called upon to bind your client to a legal position when you don't know if the client has approved that, that's when I think you need to consider making a motion to be relieved. Because, number one, you're appearing without authority. You're taking a position without client authority, which could have dire consequences to the client if truly that's not what they want. And also, you're running the risk that if they pop back in later and they say, you know, they could say, I specifically told you not to take that position. Or they could say, I didn't authorize you to take the position. I was here all the time. You didn't really make a great enough effort to find me. You could end up with a state bar complaint, and I don't know that the state bar would be so understanding if your response was, I didn't know what the client wanted, but I assumed this was okay, so that's what I did. Yes?
So let's assume that our client has been missing for 2 years. We're at a hearing where the court wants to terminate parental rights. We've already made motions to be relieved. They've all been denied. The court looks to us for our position. We don't have direction. We're assuming they don't want their parental rights terminated, but we don't know. They might want them terminated. Should we just indicate we have no direction from our client since we're stuck participating in the hearing?
And what's the case that
Well,
says that?
again, the question is, should you tell the court, I have no direction from my client? You know, it seems to me that if it's been 2 years and you haven't had any contact with the client, if you were to make the statement to the court, I have no direction from my client, period, the court could misinterpret that to mean that you've spoken with the client and the client doesn't have a preference. So, again, I mentioned at the very beginning about duties to the court, but also sometimes you have duties to opposing counsel. You have to be careful because a lawyer doesn't always have an obligation to speak. So, for example, if you're dealing with opposing counsel and opposing counsel says something to you and you know the opposing counsel doesn't have the right facts, you can't mislead opposing counsel. But if you don't say anything, you don't necessarily have a duty to volunteer facts that are adverse to your client to opposing counsel. But once you say something, Your Honor, I don't have direction from my client, silence, the court could misinterpret that, and then you run the risk of later the court saying, you led me to believe that you were in communication with your client, and the client said, I don't have any direction for you. So you have to be cautious.
My question isn't volunteering the information, it's when the court is requiring or asking you a question, should you just stay silent and ignore the court?
You can't stay silent and ignore the court. You can't do that.
So what response should
The response has to be, I think, Your Honor, I am not able to competently represent this client nor respond to Your Honor's question because I am not in contact with the client. I must request that the court put this hearing over to permit me an opportunity to try to locate the client, or alternatively, Your Honor, I'm going to have to file a motion to be relieved as counsel. Yes?
99% of the time, the court's going to say no and then terminate parental rights. So let's say that client resurfaces, files a notice of appeal. Then what happens to us when we didn't object? That's our concern. Is we don't know what to say because we can't get off these cases, and
Well, if that's a situation where your clients regularly disappear and the court won't let you out and the court is looking to you to make a response, and in your experience representing these types of cases, you know that that's a likely event, then when you have your initial communication with the client, talk to them about this and the possibility that this may happen, and either get some confirmed documented instruction from them that you can carry forward. And you also want to, and private lawyers do this in retainer agreements. In my retainer agreement, even though the majority of my clients are lawyers who don't disappear, we have a paragraph which says, you agree that as a client, this is your duty to stay in contact with me, to keep me advised as to your current address, to respond to me when I communicate with you. You can put this into your retainer so that later when the clients disappear, if heaven forbid you end up with a sanctions motion from the court or a state bar complaint, you can say, at least to the state bar, because a fee agreement is confidential under the B&P code, but at least as to the state bar, if there's a complaint, you can say, my client breached the duty and refused to communicate with me, and I had no choice. Yes?
There was a case where a judge here tried to get me to represent a client who refused to have an attorney. She refused to talk to me, she refused to communicate her desires, her position, and adamantly refused to have an attorney represent her. The court doesn't want to proceed and let her self-represent herself, so she's finding her not competent to represent herself, and she's requiring for me to represent her, but the client won't speak with me. So is there not an ethical duty for me to tell the court that I can't represent this client because there's no way for me to, no.
That's what I've done.
So, she won't, so, I told the client very clear, I told the court very clearly that the client wasn't desirous of an attorney, didn't want representation, but she wanted to force me to represent her. Because I think the problem is the court doesn't want to deal with a client like that
Right.
and letting her represent herself.
Right. So again, the question is, what happens when the court is insisting that you represent a client who refuses to cooperate and doesn't want you as their lawyer?
Exactly,
I mean, I don't know, part of it I think is probably administrative issue for your department. You know, what is the authority of the court to unilaterally appoint a lawyer who, you know, has not been assigned this case through normal channels? So one thing you could do is maybe see if administratively there can be some sort of objection made. But I think that generally the answer is the same, whether it's the client disappearing or the court trying to force upon you representation of a client who doesn't want to. We all have a duty to provide competent representation, and if we are unable to do that because the client will not communicate, it is grounds to be relieved as counsel, it's ground to withdraw. If you bring the motion and the court denies it, at least you have that level of protection. Yes?
Just in terms of competent representation, we have really high caseload, and the ABA recommends we have 100, the Blue River Commission recommends 188 with the support person you share with one attorney. Let's pretend I have 275 and 1/6 of a person supporting me, and nothing's being done to put a cap on or decrease my caseload. How can I continue to ethically represent my clients when that is my workload? And I can't refuse an appointment because I think my employee handbook says that if I am insubordinate, I can be fired.
Well, you have just described the situation that, you know, the DAs have been raising for, and the public defenders have been raising for a very long time. And it's a budgetary problem, and to some extent it's a political problem. You know, if governmental agencies or quasi-governmental agencies don't have sufficient funding so that lawyers can competently handle their workload, what do the lawyers do? And a lot of times lawyers have dealt with it through union activity, and other times lawyers have dealt with it by filing lawsuits. But as a practical matter, I think we as lawyers have to do the best we can with the circumstances that are presented to us. And if you have a situation where you simply cannot competently represent the client, you know, maybe in that hypothetical caseload, you know, 200 of the cases can be handled because they're not active at the moment. But, you know, next week there is a case that can't be handled because of, you know, 3 factors, including the client's not available and you don't have any guidance. I think that, you know, in those cases, what I would recommend is that you bring the motion, and if the court denies it, nobody can criticize you for not bringing to the attention of the court that there was this issue, and now you're complying with the court order, which should be sufficient to fulfill your ethical duties.
We don't have support staff to write the motion.
One here, one there, and then you. How are we doing on time? I think we're pretty good.
In our court system, when somebody is not competent, they make us, as another attorney, be their guardian ad litem. Do you know what that would require us as far as responsibility goes? I mean, because in our system, when you've got somebody who is not capable, that would otherwise maybe have a conservator or something like to that effect, the court system will appoint one of us as a GAL to them. It's a little unclear. I believe as a GAL, we're acting in the client's shoes, and we're the person who negotiates with, you know, the attorney. However, what does that make you? Because I'm an attorney, number one, you know, and then, but I'm acting as the client, so I'm not sure where my duty is as far as that type of representation. I mean, we sit there, we're not supposed to speak because you have the attorney who represents the mother or whoever. But what ethically kind of role do we have there?
Well, that's a novel question. So if the court's appointing someone from your office as a guardian ad litem, you're right. As a guardian, you essentially step into the shoes of the incompetent or the conservatee, and your job is not to represent them, but rather to be them. And so if it's an administrative issue and you're supervisors and administrative staff don't want lawyers in your department to substitute for other types of GALs, you know, there should be a family member, or maybe go to the public guardian's office